And good morning, one and all. Welcome to Professional Insights, brought to you by the National Referral Network. This is where we share, you guessed it, professional insights with all business owners, professionals, anybody who wants to make use of this and think they can and thinks they might benefit from it. If you like what you see, please hit the like and subscribe button at the bottom. We really, really appreciate it. We create this content each and every week, again, for everyone's benefit. So we have a guest who we're going to bring in here. Hey, Omid. This is Omid Khalifeh. Omid is a trademark attorney. He's a trademark and patent attorney in Beverly Hills. He's got the sun right behind him, which makes him look all the more angelic.
Good morning, everybody.
Good morning. And I've been wanting to talk to you for a while because I don't really understand trademark law, but the more I understand it, the more I'm aware that A, it's super important, and B, a lot of business owners don't pay attention to it and probably should. So walk me through why it's important and what are business owners missing?
Mm-hmm. Well, you're absolutely right, Mike. So first and foremost, the purpose of trademark law is surprising to some, not intended to protect the business owner, but actually designed to protect the consumer. So the standard for trademark infringement is likelihood of consumer confusion, which means that what is the chance that somebody looking at the accused infringing mark would purchase these goods and services under the mistaken impression that they're associated with your brand. So one example would be if somebody were to file a trademark application for the mark Nike, let's say, but they put a Y at the end of theirs, their application for registration is going to be rejected, even though the famous brand Nike doesn't have a Y. And that's just because somebody going into a shoe store seeing the applicant's Nikes with the Y alongside the famous brand Nike might think that the two companies are related to one another, and that's not allowed under trademark law.
So in Coming to America, McDowell's, the restaurant that was like McDonald's, that would never have happened.
Exactly right. Exactly right. Those golden arches would have been reserved for the one and only McDonald's.
For McDonald's. Okay. Okay. So it's about protecting identity for the sake of the consumer. But where do business owners often get themselves into trouble?
So one of the most common mistakes we see with business owners who are unaware of trademark law is that they'll file their applications for registrations a bit too late. So oftentimes, the first time they become aware of the existence of such a thing as trademark registration is when they find out one of their competitors is using a business name that's very similar to theirs, and that's causing consumer confusion. People will call them up and say, "Oh, did you guys open up a new branch in West LA? It looks awfully similar. They're using the same brand indicia. Their name is kind of similar to yours. The color palette is similar. Did you guys open up another branch?" And they'll be like, "No, we didn't. Is there any way that we can stop that?" And they'll call up an attorney, and the attorney will educate them on trademark law and let them know about trademark registration, how you go about protecting your brand by filing an application with the United States Patent and Trademark Office.
Okay.
Sometimes.
Oh, no, go ahead, please.
So sometimes if they've waited too long, they've been in business for a number of years, and they decide that now's the time to file for registration, that attorney will do a preliminary trademark search to assess the viability of the mark. What are the chances that registration is going to be granted? And they'll find that there's a conflicting registration already on file with the USPTO and let the client know that there are going to be significant hurdles to getting registration. And those hurdles could be quite costly to overcome, whereas if they had just filed their application to begin with, the application process would have been a lot more efficient and a lot less expensive.
Okay. Now, suppose somebody's starting a business and, I don't know, they want to name it, I don't know, Henderson and Sons, and they want to, as a gimmick, I don't know, use the image of, say, an elephant to be their sort of, mascot or whatever. Mm-hmm. Is that where can they run into problems there?
So anytime a new business owner is going to be using a particular design indicia, whether it's a penguin or an elephant or an Apple logo or McDonald's arches, they'll come to an attorney who will run a preliminary trademark search to assess what is the likelihood that this person will be accused of trademark infringement. if they are to use that particular design element. But
Mhm.
usually within a week at our firm, we'll provide a report to the client, letting them know what, if any, risks there are and how we can navigate those waters and hopefully avoid any allegations of infringement by a party who has registration for a similar design.
Okay. Well, and what about, and this actually happened to us, but what about images in presentation materials? Like say your business does a lot of education, presenting publicly and things like that, and you have imagery in your materials that is copyrighted material. You pulled it off of the internet or whatever, maybe it was a picture of, I don't know, Jim Carrey and Bruce Almighty or something like that. You put it on a slide or whatever, and it kind of goes out to the public. That can get you into real trouble too, can't it?
Yeah, so that's an area where copyright law and trademark law can overlap. So if you're using somebody's image, let's say an Apple logo or an Apple marketing piece, in a way that makes the viewer think that you're somehow associated with them,
Mhm.
at that point you'd be misappropriating their trademark, because there's a likelihood of consumer confusion there. The consumer is confused into thinking that there's an association between you and, in this case, Apple. Another issue that presents is that when Apple created that marketing piece, the United States copyright laws afforded them certain protections, and those laws prevent other people from repurposing the images that Apple's photographer took, that now Apple has the rights for, and using them in their, in this case, presentation in a manner that's not authorized by them.
And suppose that so this actually happened to us because we were doing some educational stuff at my firm, Protection Point Advisors. And we had some images that we didn't have permission to use. And there are, as this is how we found out, there are law firms out there, all they do, and I don't know how they do it, but they search the internet for offenders.
Mm-hmm.
And then they send them letters saying, well, the damage is this, we estimate. It cost us, I think, about $800. So it wasn't really that big a deal in the grand scheme of things. But if you're doing this on a much larger scale, you can get really whacked with this, can't you?
Yeah, that's true. We see it all the time. So the best advice is, first thing to do when you receive one of those nasty letters is go to an IP attorney and have them assess what is the viability of the allegations that are being brought against them. Also contact your web developer or whoever's in charge for posting that content and make sure that they take it down as soon as possible. And then get an opinion from the attorney as to what are the best next steps to take to avoid having this matter escalate and ultimately land you in court.
Okay. What size penalties? I'm just curious. What size penalties have you seen? How much money can sometimes they go after?
So statistically speaking, 99.8% of all lawsuits filed in the United States settle without making it to a verdict from a judge or a jury.
Mm-hmm.
So there's a high probability that if you receive one of these letters and you end up in court, at some point or another, you will be settling. Ultimately, the damages that are awarded are going to be determined by the finder of fact, whether that's the judge in one particular case or a jury in another. They can be quite substantial, but the likelihood that you're going to make it all the way to that point is very, very low. Usually your attorneys will figure out early on what risks you're facing, and then together you'll make a decision as to what's the best approach.
So is it fair to say that they want to push you to the point where it's more expensive to litigate it, so you won't and you'll just pay them?
That's almost always the case.
Okay. So it's a lot of gamesmanship, and there are firms out there that specialize in this. This almost seems predatory in nature, but it's legal, right?
Yeah. Unfortunately, it does seem predatory in nature, and there's not a week that goes by that our firm doesn't get a call from somebody who's received one of these letters. So yeah, it is quite common. But unfortunately, yeah, it is legal, provided that they've done their due diligence and the allegations that they're asserting are legally viable.
Okay.
And then at that point, it's It's just important to make sure that you have a good lawyer in your attorney, and a good lawyer in your corner who can advise you on the risks and what the best approach is to dealing with it.
So if somebody is, you know, they're thinking of hiring a trademark attorney or a patent attorney, or they're wandering into this realm, but they don't know what questions to ask, what should they be asking? What should they be looking for?
Mm-hmm. Mm-hmm. So there, even within the niche area of intellectual property law, there are quite a few subspecialties. So some attorneys will specialize in copyrights, which deal primarily with the creative space. So works of art, authorship, musical compositions, movies, things of that nature. Then you move over to the area of trademarks, which are primarily focused on branding. So a trademark attorney can help you file applications to register your name in the United States, as well as other patent and trademark offices all over the world if you're a global brand. And then it's inevitable that your business will do some innovating and come up with something new and unique to it that gives it a strategic advantage in the marketplace.
Mm-hmm.
And they want to protect that idea from being copied by one of their competitors. And in order to secure rights in an idea, that's when you file a patent application. And
Okay.
patent attorney can help you register those rights also in the United States and through patent and trademark offices all around the world.
So it sounds like if you have an idea, you don't want to. It sounds like you don't want to wait on this. It sounds like you want to file this sooner rather than later, more towards the beginning of the idea rather than the end of it. Is that right?
Yeah, you're absolutely right. In most countries, you only have 1 year from the date of first public disclosure of your invention in order to file a patent application on that invention. So from the moment that your idea is no longer a secret, there's a clock that starts ticking to the date that you're allowed to file for a patent on it. And if that 1 year window closes, your invention is said to have fallen into the public domain, which means anybody who wants to can pick it up and execute it and not have to pay you for it.
And are there people out there who just not protected their idea? They think their ideas are protected in perpetuity, and they're not. And all of a sudden, they become public domain, and all of a sudden, they're like, wait a minute, I don't own this anymore.
Yeah, I mean, we'll oftentimes get calls from people who rightfully think that it's just not fair that somebody gets to use their invention and not have to compensate them for it. But unfortunately, if they haven't followed the guidelines and operated within the requirements of the patent law, the government is not going to give them that protection that they're looking for.
Okay. So as we kind of wrap up, this is kind of fascinating because it sounds like anybody who wants to build an identity, wants to build a brand, should talk to somebody like you, because you're going to walk them through how to do it and how not to get themselves in trouble and all of that stuff. You kind of know where the landmines are buried, right?
Yeah, definitely. Meeting with an IP attorney early on in the development of the business can really lend a lot of insight into what the next step should be with respect to branding in particular, because you want to make sure that when you're investing your branding efforts, which is oftentimes one of the most expensive parts in growing a business, as that marketing expense, you want to make sure that you have a brand that you can protect, because the last thing you would want is to end up spending tens, if not hundreds of thousands of dollars in marketing fees for a brand and then receiving a cease and desist letter in the mail letting you know that you're misappropriating somebody else's rights. And then you have to go through the branding process all over again, not to mention the damages that you may have to incur as a result of a lawsuit.
And we certainly live in an age where identity and brand is more and more important. Do you also, I'm trying to figure out how to word this, do you counsel with your clients about, how to, like maybe they come in with an idea that's not fully developed? Do you work with them on maybe how to focus their ideas a little bit more, both in terms of protecting it and developing it?
Yeah, we oftentimes will counsel clients on the patent landscape because they want to know what is the likelihood that I'm going to be accused of infringing on somebody else's intellectual property if I bring this product to market. So that's when we're retained to do what's called an infringement analysis, where we look through the USPTO database, find any potentially conflicting patents, and then do what's called an infringement analysis to determine whether or not our client's proposed invention would fall within the scope of one of these existing patents.
All right. And again, as we wrap up, I'm gonna ask you a tough question here. Okay, so I didn't mention this at the beginning. I should have, but you're the founder of Omni Legal Group in Beverly Hills. You know a lot of lawyers. There are a lot of lawyers everywhere. What do you feel like is your firm's particular superpower?
That's a very good question. I think one thing that separates patent attorneys from any other area of practice is that in order to practice in the patent space, you're legally required to have a science background. There's an additional bar exam that patent attorneys have to take in addition to the state bar exam. It's called the patent bar. And in order to be eligible to sit for the patent bar, you have to have a bachelor's of science at the minimum. So all the attorneys at our firm have science backgrounds ranging from physics. My background's in neuroscience. We have attorneys who practice in the chemical space, biotechnology and software. So it really runs the gamut, and that enables us to communicate more effectively with our inventor clients in particular. But we also have a lot of experience with big brand names that we've worked with, and that helps us in the trademark space.
Right. Wow. Okay. So in other words, you've got the pedigree one needs to do the work right.
Yeah, we've met all the legal requirements for licensure, and yeah, we've been practicing in the space for 15 years now, and yeah, we really enjoy what we do.
Okay. Well, look, I really appreciate your time here today. This has been super informative. We've never talked with an attorney about this before, and now I'm realizing, oh, we should have done this a long time ago. See, I think there are a lot of business owners out there are going, oh, well, I should talk to somebody like him. It's a kind of it's a minefield out there, and you don't want to get yourself blown up. Omid, thank you so much. We will be back again next week, everyone, with more professional insights. Again, hit the like and subscribe button if you like what you see. And we welcome your comments, emails, questions, all that stuff. We'll see you all again next week, folks. Thanks, Omid.
It was a pleasure. Thank you, Mike.